Welcome back. You're watching Power Lunch on CNBC Africa. Well, 5 years into the Financial Advisory and Intermediary Services Act, and it would appear that unhappiness is growing about some aspects of the FAIS Act and also about how the Financial Services Board is applying it. In a matter that's starting to come to a head, the FSB has been accused of bully boy tactics and of being unapproachable, with smaller brokers afraid to complain in case they lose their licenses to operate. Well, we've been trying to get the FSB into our studio to respond to this, and of course we will keep on trying that. In the meantime, I'm joined by Chris van der Walt. He's the CEO of ISS Compliance. Chris, thanks for coming in this afternoon. And where does ISS Compliance stand in all of this? What's your involvement?
Stephen, we're an independent compliance firm, and through that we serve quite a number of the affected parties. And we've assumed the role of whistleblowers, making 3 independent and effective whistleblowing mechanisms now are now compulsory for listed companies, and we feel that the same should apply to the regulator.
Why do you feel you have to blow the whistle here?
Firstly, I'm a critic of the Act and the Financial Services Board, but I'm not an enemy. This Act, or something very similar to this, must succeed for the sake of consumer protection in South Africa, and our concern is that the manner in which it is currently being applied and the direction that things are going, this is not going to happen, and ultimately a type of a backlash which is currently beginning to develop will actually prejudice consumers and not benefit them. So it's from that perspective that we're trying to raise a few flags to say, hold on.
Of course, we know that the Act has been running for a number of years now. Why has it taken so long for these pitfalls to actually emerge in the Act?
I think it's a natural consequence of any new piece of legislation. Generally, my experience tells me you wait about 10 years for something to be bedded down finally. So, from that perspective, I believe we still have some time, provided that some corrective action is taken now.
What are some of the problems with the Act as you see it?
I think the overarching consequence of the problems, if I can start there, if you don't mind, and work my way back, is that the Act, the way it's being enforced now, will lead and is leading to disintermediation, so that the ranks of the smaller financial advisors is beginning to be decimated, which ultimately will force the majority of consumers who are so deserving of good quality advice to direct marketing channels.
So that is going to cut down on competition in the industry, I should imagine.
I think that it will, and it's also going to cut down on the accessibility of good quality advice. The 3 main arguments that we're premising our sort of conclusion on is, firstly, that from a structural perspective, the Act lacks sustainability. Ethically, it seems to be a bit of a mishmash. It uses principles of utilitarianism to cross-subsidize principles of right and so forth, and it creates a very uncomfortable position for subjects to be in. I think legally the process whereby the registrar of financial services providers can almost rule by decree, which is a common phenomenon now, but something which again raises some warning flags, is a cause for concern, because the due parliamentary process for getting amendments to a piece of legislation through are not there and are not in place. So structurally is particularly one problem. Secondly, the manner in which some of the provisions of the Act are currently being enforced by the registrar is cause for concern. To give you an example, I think normal discourse would dictate that if you want something from someone, then firstly go and ask for it. What we find in practice is that the registrar corresponds with financial services providers and starts off by saying, give us reasons why we shouldn't cancel your license, why we shouldn't take away your means of earning a living, and then work their way slowly back from there. And it's not good communication. It doesn't bode well for good relationships with the regulator. And then lastly, I believe that the good reason for becoming a whistleblower is because there's a perceived lack of cooperation from the side of the Financial Services Board. There's an extreme reluctance to issue practice notes and guidelines, which will make compliance to the provisions of the Act so much more, so much easier. It's very difficult to get meetings with them. It's very difficult to get them to hold to minutes of meetings where certain decisions have been made in the past. So from that perspective, we are saying if the situation is allowed to carry on, we would need to call for some other body to intervene.
Have you actually tried to have a meeting with the Financial Services Board to discuss these concerns?
On many occasions, we have tried to the extent that there's now been, in some instances, flat refusals to even meet with us to discuss some of these aspects.
Okay, you say the FAIS Act is flawed as it stands at the moment. Can it be sorted? Because we know that the Act is there to protect consumers.
Absolutely. Yes, it can be sorted. It can be sorted very simply by addressing the ethical aspects where consumer rights are given too much preference over the rights of financial services providers. So structurally that should resolve it. It can be addressed very simply by adequately skilled staff, and in particular staff with communication capacity and ability from the Financial Services Board side, communicating in a proper fashion with financial services providers so that there's not this issue of mixed messages. And lastly, with a few small amendments to, for instance, the manner in which complaints and disputes are managed by the FAIS Ombud being one, and also the Board of Appeals, which is an archaic institution in the context of this particular piece of legislation. I think if those things are addressed, will resolve matters very, very quickly.
Do you think that the FSB lacks the infrastructure to be fair and administratively competent at this stage?
I didn't get the question. Do you
think they lack the infrastructure and the ability to be fair and to be administratively competent at the moment?
Yes, I think they certainly have the will, but I think that the infrastructure doesn't permit them to do so.
Which other avenues do you have if you cannot get a meeting with the FSB?
Then we must vote with our feet.
Well, okay, let's look at the legislation itself. Why it was introduced and where you think it has actually veered off path.
All right. The legislation was introduced. The primary and overarching objective is consumer protection. It intends achieving consumer protection through four mechanisms in the main. One is the regulation and professionalization of financial intermediaries, access to adequate and relatively cost-effective dispute resolution mechanisms. Beg your pardon, I'm losing
do you think it's too onerous for small brokers to actually comply with the legislation?
The way that it's currently enforced, yes, I think that it is.
I mean, how has compliance been since it was introduced 4 years ago?
Well, compliance is problematic specifically for small brokers because of the wealth of information that they have to gather and then act upon. And certainly, again, going back to the manner in which it's being enforced by the Financial Services Board, I think sometimes are very unrealistic demands made on some of the smaller brokers.
Chris, there are other organisations out there who also represent brokers and also represent the industry. We were hoping to get Justice van Pletser, the Chief Operating Officer of the Financial Intermediaries Association of South Africa, onto the programme today. Unfortunately, he had to cancel at the last minute. Do you know where they stand on this issue?
I think they bear the brunt of their members, and to the best of my knowledge, they are the largest independent intermediary association in South Africa, and I think they bear the brunt of their members' frustration. And one only has to follow the blogs on the websites and so on to see that they squarely in line with our thinking.
Chris, the next step, just keep on trying to get that meeting with the FSB?
Just keep on trying, whittle away at it one piece of it at a time.
Well, we're hoping to speak to the FSB in the near future about this issue, and of course then we'd like to speak to you again. So keep us posted. That's Chris van der Walt, he's the CEO of ISS Compliance. Well,